Good day, everyone. My name is Marita Meyer, and I am going to do this presentation to you today. This presentation to you as public health students will be about health law in South Africa. An understanding of the law and the legal system in South Africa is of utmost importance to healthcare professionals in South Africa when delivering health services. This is to ensure that a competent and safe care to patients is delivered so that they can make informed decisions with regard to health provision and service delivery. The first important aspect in this regard is for you to have a sound knowledge of the nature of the South African legal system. You will also have to understand the constitutional environment and its importance in South Africa. You will have to understand the operation of the Constitution in South Africa. I will also shortly discuss 3 other laws that is applicable to you working in the health environment, in the public health environment, and that is the Promotion of Access to Information Act, or PAIA Act, the Promotion of Administrative Justice Act, also PAIA, and the Protection of Personal Information Act. And then lastly, I will touch up on the latest developments with regard to COVID-19 in South Africa. South Africa does have a democratic government. Democracy refers to a system of government in which the power is vested in the people, who rule either directly or through freely elected representatives. In a democratic system of government, the relationship between the government and the people is not simply based on power. The pillars of democracy are free and fair elections, active participation of all citizens, or individuals or institutions, that must all be given the opportunity to take part in the making of decisions that affect them. Protection of human rights is also a pillar of democracy. Human rights in our country is contained in the Bill of Rights as in Chapter 2 of the Constitution of 1996. The rule of law refers to limiting the power of the government. It means that no person is above the law. We are all equal under the law, and the authority of the government is legitimately exercised only in accordance with the law. The government, its officials and agents, individuals and private entities are all accountable under the law. We have 3 levels of government in South Africa, 3 levels or 3 spheres. In the first place, it is the national level or sphere, the provincial level, and the local level of government. All of these levels have legislative and executive authority in their own spheres and are defined in the Constitution as distinctive, interdependent, and interrelated. We have different state institutions in South Africa supporting democracy. This includes the Public Protector, the Human Rights Commission, the Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities, the Commission for Gender Equality, the Auditor General of South Africa, and Independent Communications Authority of South Africa. The government is committed to the building of a free, non-racial, non-sexist, democratic, united, and successful South Africa. Our government has 3 main structures or 3 main spheres. In the first place, it is the legislative authority, which has the power to pass new laws, to amend existing laws, and cancel old laws. This authority is exercised by the Parliament at national level through the President and the Cabinet, At provincial level, through the provincial legislatures, by way of the provincial premiers and executive councils, and at local government level, through the municipal councils by way of the executive communities. Our parliament consists of two houses, namely the National Assembly, which is the president, and then also the vice president or deputy president, and then the cabinet, which is the ministers and deputy ministers. There is also the National Council of Provinces, which is the delegates for the different provinces. The executive authority has the power to execute and enforce rules of law. This authority is exercised also at national, provincial, and local levels. At national level, this authority is vested in the President, who is the head of the Cabinet, and he exercises this authority together with the members of the Cabinet. At provincial level, this authority is vested in the Premier of the province, together with the members of the Provincial Executive Committee. At municipal or local level, this authority is vested in the municipal councils. The judicial authority is our courts. So if there is a dispute, the courts determine what is law and how this law should be applied. Our courts include the Constitutional Court, which is the highest court in South Africa, the Supreme Court of Appeal, the High Courts, and the Magistrates' Courts. The Judicial Service Commission appoints the judges. The doctrine of trias politica. This means the separation of powers, and the main objective of this doctrine is to prevent the abuse of power within the three main spheres or structures of our government. These spheres are separated. It means that if one sphere is responsible for the enactment of rules of law, that sphere shall not be charged with the execution thereof or with the judicial decision of them. The French philosopher or jurist Montesquieu is credited with advocating of the division of government functions. He supported this by saying that all would be in vain if the same person or the same body of officials, be it the nobility or the people, were to exercise these three powers, that of making the laws, that of executing the public resolutions, and that of judging crimes or disputes of individuals. In South Africa, there was two case laws with regarding this. The first one was De Lange versus Smits and others, where the Constitutional Court held that a member of the executive may not be given the power to commit an uncooperative witness to prison because this was a judicial function and not an executive one. In the South African Association of Personal Injury Lawyers versus Heath, the Constitutional Court also held that a judicial officer may not be appointed as the head of a criminal investigation unit because the power to investigate and the power to prosecute crimes is an executive function and not a judicial one. The legislative process. The Parliament is the law-making body of South Africa. Both houses in Parliament, namely the National Assembly and the National Council of Provinces, play a role. A bill or a draft can be introduced in Parliament by a minister, a deputy minister, a parliamentary committee, or an individual member of Parliament. This process usually starts with a discussion document being called a green paper. This green paper is then published for comments, suggestions, or ideas in the Government Gazette. Then follows a white paper, which is a broad statement of government policy, and the relevant department is drafting it, and amendments may be proposed by relevant parliamentary committees. The white paper is then sent back to the ministry for final decisions. Then a bill is drawn up by the relevant department under the supervision of the minister or deputy minister. The bill is then approved by the cabinet before being submitted to Parliament. The State Law Advisor certifies a bill as being consistent with the Constitution, which is the highest law. Both houses of Parliament must consider a bill. If the National Assembly and the National Council of Provinces approve this bill, it goes to the President. Once the President signs it, it is law of our country or an act of Parliament. It is important to note that the President can only refuse to sign if he has reservations about the constitutionality of this bill. Then it must go back to the National Assembly and the National Council of Provinces. Two words that is important to know is that concurrence. This is when the legislation is sent to the other house to agree or to not agree. And assent is when the President signs a bill and make it an act of Parliament or a law of land. The difference between law and policy. Law sets out standards, procedures to be followed, and if this is not followed, it could lead to prosecution in court. A policy is not law. It is a document by which new laws needed to achieve certain goals can be identified.